term. I'm lead counsel for Jordan Brown. I'm assisted by my lead co-counsel, Stephen Cauliflower, seated to my left. Seated to my right is Chris Brown, the father of Jordan, and of course, to Steve's left is Jordan Brown, our client. Absent today is the Juvenile Law Center from Philadelphia. I want to point out that they've been instrumental and an invaluable asset and co-counsel on this case. In particular, their senior attorney, who is not available today, Marcia Levick. The junior attorney who started and assisted her from the beginning of the case, was with the case and on the case for a good 3 or 4 years, was Lourdes, Lourdes Rosado, Rosado. She's moved on to a different job. She was replaced by attorney Catherine Kate Burdick, B-U-R-D-I-C-K. She's still with us on the case. She's unable to attend, but I do want to point out for everybody's benefit that they're entitled to a great deal of appreciation, and their assistance was invaluable. I'll give you a synopsis of the case, but before we get there, when I'm done speaking, you're welcome to ask questions to everyone but Jordan. He's not going to answer any questions, and I respectfully request that nobody ask him any questions. He's 20 years old now. He'll be 21 at the end of August 30th, but nevertheless, it's our collective advice that he's not to be asked any questions at this time and not answer any. Chris is fair game, but of course, would like to point out that we have to keep the questions within the scope of why we're here, and of course, any questions for me and Steve are certainly welcome. This case started on February 20th of 2009. The underlying homicide, double homicide, occurred anywhere between 8:16 to roughly 9 o'clock. The investigation lasted a total of roughly 16 to 17 hours. The result was the arrest of an 11-year-old child who's now seated with us today, who's been exonerated. And the case proceeded for, as I said, 9.5 years. The procedural history is quite extensive, so I'll give you the Reader's Digest condensed version. I do want to point out a couple things. I was hired within hours of Jordan's arrest by Chris, and that occurred early morning hours of Saturday, February 21st. The media got wind of the fact that an 11-year-old was charged in a double homicide as an adult over the weekend. The morning of February 23rd, Monday, what normally would take a 3-minute walk from my car into the courthouse for a 9:30 court appearance took 2 hours and 45 minutes because of the population of the media who were following the case. From that moment throughout today, there have been 2 things that have been consistent by the defense. One is that we have, and I have personally and professionally, always expressed my sincerest, heartfelt condolences and compassion for Kenzie Howe and the loss of her life and her fetuses. There are many victims in this case, and I always expressed my condolences and sympathy and compassion for them. The second thing that I consistently have represented throughout these 9.5 years is a staunch and certain belief and conviction in Jordan Brown's innocence. No one in this room, including the people seated with me, other than perhaps Chris and Steve, understand the facts as well as I do. I have maintained, as has Steve and Chris and Jordan, his innocence of these charges. We believe there was a rush to judgment, and we also believe that he was the casualty of a system that broke down. The first publication that hit on that Monday morning was a London Globe front page picture of Jordan. Somebody at the Lawrence County Correctional Facility, where Jordan had been housed since early morning hours of Saturday, February 21st, had surreptitiously disclosed the booking photo of Jordan as an 11-year-old, which everyone has seen over the years. The cover sheet page of the London Globe was his picture. It covered the entire front page. The 6-inch headline simply read, "The World's Youngest Monster." That, in our estimation, fueled a media frenzy, and I believe that Jordan has been unfairly and unjustly crucified by the media in this case, and I believe that the media has fueled the legal developments that occurred over the course of the 9.5 years. As to those, we had a preliminary hearing, after which time the charges were bound over. At that time, I was co-counsel was Dave Acker, who has since been elevated to Court of Common Pleas judge in Lawrence County. The charges were bound over against a very vigorous defense that the charges were not even sufficient at that point to proceed any further under even a probability standard. The next step was a petition to decertify the case, meaning transferring it from adult court to juvenile court, which is a huge, significant aspect of the case from a defense standpoint. To our surprise, our president judge declined to transfer it, ruled in favor of the Commonwealth, thereby putting us in a position that we had to ask that particular judge his discretion, its discretion, that court's discretion to pursue an interlocutory appeal, asking the Superior Court to please let us consider appealing that critical issue while the charges were pending and not wait until the trial was over. Had we not gotten permission from our president judge to pursue that, then Jordan would have been faced with the prospects of going to trial as an adult in a double homicide prosecution. He was the youngest person in American jurisprudence in the history of American justice to be facing adult charges for homicide as a 11-year-old. Fortunately, our president judge granted us his discretion, allowed us to appeal. The Superior Court likewise allowed us to appeal. And then the Superior Court then reversed the trial court, directed the lower court to disregard any testimony from the expert for the Commonwealth on the decertification issue, and prohibited the Commonwealth from calling any other witnesses in that regard. Obviously, then our lower court judge, president judge, transferred the case to juvenile court. The next step was to get ready for trial. By then, after the decertification, Attorney Caulifella graciously agreed and accepted my invitation to be co-counsel for the balance of the case. Prior to conducting a bench trial on the juvenile charge of double homicide, the media got involved once again and petitioned the courts, various outlets petitioned the juvenile court to open the proceedings to public, which is largely prohibited. The juvenile court judge denied it, and the media took that up on appeal. The Superior Court of Pennsylvania declined to open the matter to the public. Simultaneously, we, the defense, filed what's known as a petition for writ of habeas corpus, claiming that Jordan should be released because the delay in getting him to trial was not occasioned by us, but it was instead occasioned by the media wanting the trial to be publicized. That was denied. That was our only loss at the appellate court level. That was denied by the Superior Court. The case then was remanded for trial. The first trial took 3 or 4 days. It was a bench trial, after which time the juvenile court judge adjudicated Jordan delinquent, which is the juvenile equivalent of a jury finding an adult, convicting an adult, and finding an adult guilty. So as per the juvenile court's ruling, after the conclusion of the first bench trial, the the adjudication of delinquency was in place. That prompted our third appeal to the Superior Court, in which we maintained that we were entitled to a new trial, and the Superior Court agreed with us that the evidence was against the weight of the evidence, the conviction was against the weight of the evidence. The Commonwealth appealed that to our state Supreme Court, which was the case's first appearance in our state Supreme Court. We argued that state Supreme Court case in front of the Supreme Court sitting in Philadelphia. The Supreme Court agreed with us and directed that the case be remanded for further for a retrial. We then pursued the route of an alternative theory to, we then had a second jury trial, which is an abbreviated trial in which basically the court relied on the transcripts of the first trial. The court again found adjudicated Jordan delinquent. We then took another appeal to the Superior Court. That is one of the more critical stages in this criminal prosecution, because we were able, with the Supreme Court's invitation, we were able to argue two theories. One is one that is rarely argued, let alone granted. The argument is that taking the evidence in a light most favorable to the Commonwealth and considering all of the Commonwealth's evidence and the entire record is true, that the verdict was insufficient as a matter of law, that no reasonable person could conclude that Jordan was responsible beyond a reasonable doubt. The backup argument was the same argument we had advanced successfully years earlier in the Superior Court, and that is that the evidence was against the weight of the conviction was against the weight of the evidence, and that it was entitling us to a new trial. The Superior Court agreed with the lower court at that round of appeals. We then petitioned for an allowance of appeal to our state Supreme Court. That sort of petition is rarely granted, and usually within 30 to 60 days, that petition is denied without any discussion. It's a one-sentence order. Stephen and I have seen it many times. Instead, the Supreme Court sat on our petition, studied it, analyzed it, and 9 months later granted us permission to pursue it. Briefs were quickly and timely filed, and we were scheduled and did conduct oral argument before our state Supreme Court, now sitting in Harrisburg, on November 29th of last year. They took a considerable amount of time with Deborah Todd writing for the majority after oral argument, and we all know where that led us, which was this past Wednesday, July 18th of 2018, a resounding victory for the defense, an acceptance and an agreement on what we've been saying for day one, that this case should have never gone to trial, and that Jordan should have been exonerated. Our Supreme Court unanimously, 5 justices concurred, ruled not the backup argument, but the primary argument that the evidence, the conviction, was not supported by sufficient evidence, and that Jordan, instead of getting a new trial, should be outright acquitted and discharged from any further punishment. And that's precisely what our Supreme Court did by opinion filed this past Wednesday, July 18th. The exoneration is largely unprecedented, but it speaks volumes as to the insufficiency of the case, of the evidence of the case. We are not here to flaunt anything. We're not here to gloat. We're not here to brag. We are here to simply let you see Jordan, to see that he's grown into a young man, and we can all vouch for his intelligence and his responsibility. How he does it, I don't know, but he harbors no ill feelings or malice. I believe that, I don't believe, it's a fact that Jordan and his father, Chris, are also victims of this horrific, heinous crime. Chris went to work that morning fully expecting to come home and be with his family, fully expecting the birth of his son Christopher, Jordan's brother, within 2 weeks. And obviously his day turned out to be the most tragic in his life. Not only was his fiancée gone and his 8.5-month fetus gone, his son, within several hours later, was removed from him and placed in a jail and charged as an adult with a homicide. That journey ended Wednesday, and it ended in a way that is just, fair, and long overdue. We are proud with the result we obtained. We are heartbroken for the loss. We are mystified as to why the true killer has not been investigated or apprehended, and we would hope that the Commonwealth, despite the delay in time, can reopen their investigation so that this family, including the victims seated to my left and right, can have some justice. I'll defer now to my co-counsel for any added comments, and then we're welcome to answer any questions you have, and thank you for attending.
Thank you. Thanks, Dennis. I don't want to take a lot of time. I know you've waited a long time, and I'm sure you have a lot of questions. Just a couple of things I'd be remiss if I didn't say here now that we've sort of gotten to the end of the road in this case, or so it seems. As Dennis said, I was not involved in the case for the first 2 years when they very conscientiously and diligently fought to have the case remanded back to juvenile court. And I recall receiving the phone call from Dennis asking that I come into the case to try the case with him. And I was very honored by that. But I have to say, at that point in time, I was, like many of you and most of the viewing public, I believe, what I knew about Jordan Brown and the case against Jordan Brown was really limited to headlines, innuendo, a number of articles that sort of scratched the surface of the case, because there really wasn't a great deal that was made public at that time. And the presumption that I had was probably the same that many had at that time and probably still have today, which is part of the reason we wanted to address the media in this case. Sort of assume, well, from what I've read and what it looks like, I mean, he's guilty. It's just a matter of whether or not he's going to be adjudicated as a juvenile or whether he's going to face criminal consequences as an adult. And I remember Dennis saying to me, read the file. Just read the file, think about it, and let me know what you want to do. And so I did. I read the file from cover to cover, and I can remember calling Dennis and telling him I can't get over this case. I just cannot get over that it's gotten to this point. And I was pretty appalled at what I had seen, that the scant evidence that led to his arrest and that actually had developed in that time preceding our trial. And I can tell you that the magnitude of this case, I think, probably contributed not only to a lot of opinion about it, but many of the things that have happened over the last 9 years. And there are many people who probably to this day who are relatively uninformed about the case may look at it and say, well, you know, that kid escaped on a technicality, or you know, our system failed again and allowed this convicted killer to go free. I can assure all of you that that's not the case. And if anyone has any doubt about that, we've left copies of the opinion over there for anyone who hasn't already read it. I'm assuming most or all of you have. I can't tell you how pleased I am with the review that was conducted by the Supreme Court and the thoroughness of their opinion and their analysis of the facts and the lack of evidence in the case. And there's actually a bit of a summary toward the end of the opinion at pages 45, 46 that really sort of synopsizes our opinion and our position and our argument to the court at the time the case went to trial. The theory of the case is to me, patently absurd in terms of the way it was suggested that Jordan Brown could have committed this crime. And so I think I can't say enough about the Supreme Court. Our Supreme Court unanimously reviewed, spent a great deal of time and articulated their thoughts and views on the case itself. And as Dennis indicated, it's extraordinarily rare that a case of particularly something of this magnitude is overturned based on sufficiency of the evidence. That just makes it so much more satisfying. It's unfortunate that it took this long. It's unfortunate that Jordan had to endure what he's had to endure to get to this point. But as Dennis said, Jordan has been an extraordinarily strong young man, has hung in there with us, has done everything that he's been asked to do, and has put his confidence in us and his faith and love in his father, who's been unbelievably supportive throughout this whole process to get us to where we are now. And I do want to say, too, that Dennis's comment that, you know, it's a position that I share and the Juvenile Law Center shares, that Jordan not be asked questions. To be quite honest, when we got this opinion last week, and you know, we never knew, we knew it was coming, we didn't know when it was going to come, and this is sort of the result that we were expecting based upon the arguments that we had in Harrisburg, and Dennis did an unbelievable job. And it really was a ray of hope to us when we walked out of court in Harrisburg in November to see the response that we received from the Supreme Court, their preparedness, not that we expected any less, and their very insightful thoughts and questions on the various pieces of evidence that were introduced in the course of the trial. It really gave us some optimism, and when we got the opinion last week, it was still somewhat surreal to see it on paper. And we really vacillated on whether or not we were going to do this, or whether we were going to have Jordan appear to in front of the cameras, because you know that has not happened up to this point in time. And our position was really ultimately this: anybody who knows of the Jordan Brown case, and it's received attention, media attention, and articles all over the world, what we want everyone to walk away with from today and going forward is not the impression or the opinion that, frankly, I had and many others had, 7-9 years ago when this all first happened, but to really understand and appreciate the gravity of what's happened here and the significance of what's happened here, and how we should all learn from what happened here, and that Jordan is a very strong young man. He's moved on with his life and could probably have moved on to a life in anonymity as best he can achieve that, accept what the court has done. But frankly, with what he's been forced to endure, we also felt he at least deserved the attention of people seeing the young man that he's grown into, rather than those images of that little 11-year-old boy who looked completely shocked and unaware of what was really going on at the time of his arrest, and unable to appreciate the gravity of what was happening or what was about to happen to him. So we're here to answer questions about the case, and we're here to address whatever you have in terms of the decision and how we got to this point and how we move forward. So,
and may I add, before we ask any questions, I do want to point out that there were 5 justices who ruled in our favor, hence unanimous. There were 2 remaining members of the Supreme Court, Justices Donahue and Wecht, did not participate in the decision, and the reason for that is that they exercised their discretion to remove themselves from the case, because both of them had previously ruled in our favor in granting us a new trial when they were on the Superior Court, and remanded the case for a new trial, and they had been elevated by the time this new appeal the most recent appeal came into being. They had been elevated to the state Supreme Court. So we have 5 justices concurring unanimously. The 2 who recused themselves had already previously ruled against us in our favor. So we find it to be a 100% victory with respect to the justices' assessment of our argument and our assessment of the evidence.
Mr. Alisco and Mr. Colifel, before we ask Mr. Brown questions, which will require him to switch seats to get in front of those mics, let me just ask this question. A rush to judgment, a miscarriage of justice essentially, and an incarceration that was totally unfair for Jordan Brown. Is there any kind of civil law recourse that you now have against authorities for what happened?
That would be premature at this point, but that's certainly something that is going to be investigated and possibly pursued. I think it would be incumbent upon me and in conjunction with Jordan and Chris to look into that, because if there is liability, I don't know if there is liability, but if there is liability, the reason it's incumbent upon me to pursue it and investigate it is because the damages would be quite significant. To place a dollar figure on a wrongful conviction, if it had been done in a violation of his civil rights and the destruction of his childhood, I don't know what kind of compensation would would remedy that. So I do intend to, and have already taken steps to begin the investigation into any civil action.
You have made it clear that Jordan Brown is not going to speak, but can you, on his behalf, convey anything of what his reaction was on hearing of this verdict and anything that he's conveyed to you that you can tell us about his thoughts about his future?
Well, I can tell you that, and I don't want to divulge conversations that Jordan and I have had, and I will say too, what a pleasure it's been to be able to spend time with Jordan, not in custody, not under the control of the authorities, whether that be juvenile probation or sheriffs, and be able to just kind of talk about how his life's continuing to move. Jordan, I think probably the biggest relief for Jordan was the day that he got to walk out of placement and be home with his family. Obviously, Jordan's still a young man, and I don't know fully appreciates the gravity of this decision in terms of how it impacts the rest of his life, although I think that's probably starting to set in. But he's remained, it's funny, he's remained incredibly positive and motivated, and has been taking all the steps on his own the last couple of years to kind of move forward and make future plans, reestablish relationships. So it's a tremendous relief, and I suspect it will probably take a little bit of time still before the real magnitude of what's happened and how that's going to impact the rest of his life was implicated by this verdict. So just give me this opinion. So I don't speak too much for Jordan. He's kind of a soft-spoken guy. I think I would be speculating somewhat if I went too far with that.
Are you worried, though, about people seeing him that will give him a hard time because he's been through a lot already? Now seeing his face, they're going to know who he is. And I know he can stand up for himself, but just that question.
Well, Michelle, heretofore, he hasn't had, surprisingly, he hasn't had much of that negative experience. Very isolated incidents, and I think moving forward with this exoneration, that he's going to have even less difficulties. He's a strong kid, doing his own thing, going to college, working, and he has friends, and so I think he's going to be pretty much treated respectfully and deferentially, and if he hadn't experienced a great deal of negativity while the cases were pending, while he was during time frames where he was actually adjudicated delinquent, with the media negative coverage, I don't think he's going to have any problems moving forward with this opinion.
You mentioned college. Can you tell us a little bit about his future plans?
Computer science. He'll be a sophomore here, starting back up the end of August, beginning of September, and information, not technology, information business systems. He spoke. So he's already declared a major. You're welcome.
What do you want to see happen in terms of the murder and it being solved?
I would like the police to sit down and reopen their investigation. I mean, it wasn't incumbent upon us to pursue the route they pursued. It wasn't incumbent upon us for the time lapse to occur that did occur. But I would like to think that a crime of this nature, that there is a reinvestigation and some attempt to uncover some evidence that would point in the right direction.
In the course of preparing the defense, did you come up with any potential suspects or somebody you might think is?
Well, that's an interesting question, because it's not, and the Supreme Court points this out. It's not a duty on the defense to point to an alternative possible defendant, as you well know. But since the Commonwealth's Deputy Attorney General, who prosecuted the case the first time, who's since retired, made a point of asking, if not Jordan, then who, despite our objection and retort that that's not our burden, it seemed that the juvenile court paid attention to that. So we did call a person on our defense who we suggested might have the motive and the means to commit these homicides. The Superior Court and subsequently the Supreme Court both made it clear that that wasn't any duty of ours, and if not Jordan, who else is irrelevant, because we don't have a duty to prove that. But we did call alternative suspect, but turned out that it was irrelevant for purposes of our arguments.
Why do you think that they went so aggressively after Jordan in this case? Do you have any opinion on that?
The short answer is I don't know. It didn't become a huge case until he was charged, Michelle, because of his age and being charged as an adult. The answer is I don't know why they rushed to judgment. I don't know why I believe that any kind of homicide, it does get a lot of hands-on, close scrutiny by the higher-ups, and perhaps they felt some pressure. But that would be speculation, and I don't like to speculate.
Mr. Brown, can you describe what it was like watching your son grow up in juvenile
Right.
detention, and also what this exoneration means to you?
I believe we have to switch seats. Can we?
Well, Steve, if you could switch.
I can switch, sure. Come on, Kristen.
Thank you.
Sure.
Yes, I'm sure.
To answer your question, it's, as any parent could imagine, it's something I wouldn't wish upon any other parent out there. It's been a long road. As far as getting news of the exoneration, it was kind of bittersweet, so to speak. Overwhelmed with joy, but still full of sorrow, knowing that we really won't have closure with our loss. So good to have Jordan back, have him home. Of course, he's been home, as you all know, for a couple years now. But to have the ability to put this behind us and move on, that was our main goal.
How's Jordan doing?
He's doing great. Doing well in school. He's no issues whatsoever from day one. And I know that with him being in the juvenile system, you guys have not been privy to any of the reports in the case, but at no point in time, I will say this, at no point in time throughout the last 9 years has there ever been a report that's been entered into this case that would suggest that he had any kind of issues whatsoever, psychologically, mentally. Every report has said that, he has been where he needs to be is in terms of his mental capacity, no behavioral issues. He gets great grades. He graduated with a 3.9 GPA from high school, doing well in college. So just interested to see what life brings, down the road in the future for him.
Your fiancée and unborn child were murdered.
Correct.
I know you join in your attorneys in calling on local officials. Can you state in your own words what you want local officials to do?
Well, I guess I would kind of agree with what Dennis said. It's not our job to investigate, and there are people involved in this case that are sworn to investigate. I would just hope that they would do that. I would hope they would reopen the case and pursue the actual murderer, who, by the way, has been walking the streets for 9 years.
How does your son get back his youth, though? I mean, I guess, I know that you spent a lot of time with him, but I mean, he didn't get to do a lot of the things that normal young people get to do. And do you think that's had any impact on him?
Well, can you get that back? That's the question. I think the answer in short is no. But I think what matters most is moving on from this day forward and what you do, from this day on. It's been a rough road for everybody involved. And I think we've all learned a lot of lessons in the last 9 years. So I think that, taking that, using it, moving on.
The personal toll on yourself, I mean, what is that?
Oh, I don't even think about it. It's, I'm getting by. I've done so for 9 years, so I'll continue to do so.
And Michelle, I think it's also important to note that neither Chris nor Jordan really had the opportunity to grieve the loss.
of those lessons have you learned?
In terms of,
Oh, well, you just said over.
I'm
the
just
years,
talking
but-
about the case in general, overall, life lessons.
Mr. Brown, you stood by your son through the whole process, and with what you described as a sort of critical public, I mean, did you ever feel harshly judged by neighbors, the public?
You know, I don't think that I really, I mean, obviously, there's people out there that are gonna have point of view other than ours and opinions that maybe don't agree with what we feel or believe. But, you know, you'd be surprised. I think overwhelmingly, the majority of what I've run into was support and sympathy. You know, in our community where we live, it was overwhelming. You know, people that know Jordan, people that knew Jordan from birth on, they, from day one, have supported us and believed in his innocence, and they haven't wavered from that. So, you know, that's been pretty good, you know, help getting us through to this point.
Can you tell me specifically how you two found out about the reversal from the Supreme Court? And were you shocked, surprised, just utter relief? Maybe who got the phone call, who called you, something like that?
Dennis actually called, Dennis and Steve both, and relieved would be the best way to describe what we were feeling. Shocked? I don't think so. I don't think I was shocked. I think I was expecting it. We were all expecting it, hoping for it. Cautiously optimistic, that's a term we've come to use for the last 9 years quite a bit, but just disappointed that it's taken this long. It's taken this long at the highest court in Pennsylvania to overwhelmingly rule in our favor. It's just, it's sad that it, you know, at the end of the day, if anything positive should come of this, I would hope that it's maybe the higher ups take a look at this juvenile system and how broken it is, and aspects that need to be fixed, you know, areas of concern. And I can sit here and tell you stories over the last 9 years that would just make your head spin. And, you know, at times it was like a nightmare that my kid was involved in this system. But I hope that things are learned, taken from this, and a lot of work is done to fix it.
There's that old expression, justice delayed is justice denied, even though ultimately the outcome turns out right. Is there a comment, maybe from your attorneys as well, is there something that can be done to speed up processes like this so that a juvenile is not held in custody for years and years when it's clearly not right?
Normally, John, the juvenile prosecution lasts between 6 and 12 months. This one had all the twists and features of an atypical case because of the being filed as an adult and then the subsequent appeals. So I think it's sort of unique to this case, but I do agree with Chris that there are some changes that need to be made in the juvenile justice system. If the whole goal of juvenile prosecution is to rehabilitate rather than deter or punish the defendant, which is the goal in the adult prosecution, then it sort of makes total sense that there should be an expedited resolution of the charges. And I agree with you that on the issue of justice delayed is justice denied. That's funny because Steve and I were talking about that this morning, and it's delayed and it's frustrating and it's caused me to have a lot more gray hair than I had 9.5 years ago, but I still feel really professionally, and I know Steve does too, satisfied and relieved. And I think justice was served, even though it was delayed.
In terms of the time for me, the thing most frustrating, and I often go back to day one where you know, Jordan was taken from his bed at 3 o'clock in the morning and placed in an adult jail. And I remember at that point in time, Dennis and I would go over and just try to keep him in, you know, positive spirits, and we're working on getting you out of here, we're working on getting you home. And that turned into 2 weeks later driving to another facility in Beaver County Then it went to Erie, where I drove every day for 3 years, 200 and some miles round trip to be there for 4 hours a day with my son. You know, days turn into weeks, weeks turn into months. Before you know it, you're looking at 3 years. 3 years he was warehoused at a facility that's equipped for a 28-day turnover. It's a county facility. There's no reason that a child should have been placed there for 3 years. Those are things in the system that need to be addressed and need to be fixed. And you go from those hours, weeks, you know, days, weeks, months into years, and here we are 9 years later. Half of his life he has spent in this system to get to our final day today. You know, that to me is an issue. It's an issue.
And I'll ask the same question.
So much of your life has been consumed by this, and coming to this time, this resolution now, looking forward, what is your hope for your son for this day forward, and how do you think you will spend your time going forward? You just put all this behind you, take up some aspect of this as a cause? You know, since getting word of the ruling, I think my hope for my son at this point in time, the biggest thing is that, you know, when people Google Jordan Brown, you bring up that mugshot of that night when he was 11 that was leaked from the Lawrence County Jail, and you see the headlines of, here's the 11-year-old boy who committed this crime. I would rather it be you open up in Google and you see, here's this young man who has, above all odds, come out of this okay, holding his head up high, doing great. And oh, by the way, has become a victim of, you know, being falsely accused and later having to be exonerated. You know, a lot of damage is done to Jordan in those aspects. And, you know, you Google his name and it's not good. So we're hoping to maybe change that. You know, that's what I hope for him down the road in the future. As far as everyday life and where he's going to be 20, 30 years from now, there's no doubt in my mind he's going to be a productive member of society. He's going to do great things. He's got good things coming.
Same question that I asked your attorneys. Are you looking for civil recourse of some sort?
I'm not commenting on any of that. I defer to the attorneys for that. That's something that they're working on.
It's something you would consider?
As I said, I'm not going to comment on that.
I know that Dennis had said that Jordan was using a different name for school or something, but now will he go back to using his name?
Actually, he has been using his actual name,
Yeah.
and will continue to do so.
The kids where he went to high school called him by his first and middle name, but his name was never changed.
It was never changed?
No.
Correct.
Okay,
No.
all right. I guess, do you have other family that has been supportive, that has been there through all of this to help Jordan, to help you?
Yeah, we have a pretty good support system, family and friends. And I got to tell you, you know, we owe everything to these two. It's unbelievable what Dennis has put into this. You know, from day one, never wavering. His support, the hours, everything he's done, never giving up on Jordan and always believing in him and his innocence. I thank God for these two every day. Our support system with our family is just, it's great. We have a good family, friends that have been there from day one. Jordan, for a short period of time, while he was, I'll just say for a short period of time, he was staying with a relative over in Ohio briefly. So yeah, we have family all over that have been there for us. So,
Any other questions?
Any other questions?
Thank you very much.
Thank you, guys.
thank you. And I apologize.